Welcome to Texas Probate Made Simple under the KISS principle.
Welcome back to Texas Probate Made Simple with G. Riley Hetherington. Riley is an estate attorney who helps many Texas families understand and prepare for what happens when someone passes away, especially when there's no will in place. I'm John Lieberman, and today we are talking about what happens if you die intestate in Texas. This is episode 4. What happens if you die without a will in Texas? And Riley, I can imagine if you die without a will in Texas, it can get awfully complicated and awfully adversarial.
John, I think that I can underscore that many times over. And I've talked about in all these episodes my 10-to-1 rule as far as 10 times more expensive in time, trouble, and expense if you don't have a will than when you do. But in Texas, what it means to die intestate is that you pass away without a written will that has been executed with appropriate Texas formalities. And we talked about that in the last episode of signature by 2 witnesses in front of the person who signed the will, or wholly in the handwriting of the person who passed away will. But that's the formal definition of what it means to die intestate in Texas.
So who decides where your property goes, where your money goes, if there's no will?
I don't know if you want more of your life controlled by people in a legislature or in a governmental entity, but that's what happens. They have created what is called the Texas Estates Code, which has all the provisions dealing with finding the people that are entitled to receive the assets of the person who passed away, the heirs, designating the person who's going to administer those assets and pay debts, the administrator, and then confirming in what percentages and the identity of the folks of the distributees that will receive those assets after all debts are paid. So to kind of top everything, I think the KISS principle, when you don't have a will, is probably very instructive. So K stands for known. Known specific sections of the Texas Estates Code will apply and will in most cases result in unwanted expenses and results. The 10-to-1 rule. I, investigation. An investigation will be required to identify known and unknown heirs through a costly heirship proceeding, which I'll talk about in a moment. S, selection. Selection of persons and amounts to be awarded and to be received under the terms of the heirship proceeding will be made with no input from the person who's passed away. Those rules are set in somewhat stone in the Texas Estates Code. And finally, speed. You won't get any. The speed of an estate administration will be eliminated if you had a will, and the procedures and control by the probate court for the assets and debt and distributions will be cumbersome. And let me tell you about an heirship proceeding. Mm-hmm. So an heirship proceeding is the formal probate procedures under which all of those steps are accomplished. And when you go through the heirship proceedings, there are numerous people that we'll talk about that have to be retained, paid, and input into the process. But it is a process by the court to determine the known and unknown heirs of the individual who's passed away, to determine who is going to step up and be the administrator of the estate. And finally, once the administration is ongoing for collecting the assets and paying the debts, everything will need to be reported in writing back and forth and approved by the probate court. So it's quite a process, and heirship proceedings really take into account that 10-to-1 rule that we've talked about in all these episodes.
So, Riley, does the state take your property if no heirs are found?
Well, they can. That's a rare occurrence because family trees have a tendency to be quite broad and deep, especially if only children are involved and no marriages and all those kind of things, and cousins and second cousins. It does happen. We have what is called an escheat, escheat provisions of the Texas Estates Code. And it basically goes to the state if no heirs can ever be found. But I've been doing this a long, long time, and I have never had an estate where there was no will that ultimately ended up with the state ending up with the money.
So how is probate actually different when there's no will?
The probate, again, has that heirship proceeding and a dependent administration, which we've talked about. And it also has an individual that you'll hear gets involved, which is called an attorney ad litem. This is a person, a lawyer typically, that's appointed by the probate court, and his or her job is to find and represent the unknown heirs of the person who has passed away. And that can be quite a task because they find out who the heirs and family tree is and go through all of that. But quite often they find a child of a non-marriage or a brother or sister that's unaccounted for. And it can be quite enlightening to the rest of the people involved. I have served many times in that role as an attorney ad litem, and I have found heirs and folks within the family tree that no one knew about, because you have to do a thorough investigation if you're the attorney ad litem. And the people who are moving forward with the heirship have to pay that attorney ad litem, who doesn't represent them and is simply an officer of the court performing those tasks, whether they like to or not. Back to the 10-to-1 rule.
Yeah, and that leads me to ask, can family members contest or challenge heirship?
Happens all the time. And that's typically the way that I have found the missing child, the missing marriage, the common law marriage, which we do recognize in Texas, which is not a ceremonial marriage, people living together, etc. And that's typically how I, as an ad litem, have found out about it. And it always results in a contest being thought out by a unhappy heir or a person that's been left out of the situation. And sometimes they come forward, and that's also happened. So yeah, it's a very complicated, highly litigated, and very contentious situation.
You mentioned common law spouses. What about stepchildren? Are they included in inheritance?
They are. And I think I mentioned earlier in the earlier episode about the situation where community and separate property law issues exist for a married couple. That's where many times stepchildren become an issue. And the common law spouses, that becomes an issue too, because spouses are treated very differently under Texas law, both from a community property law situation and a separate property law situation. And those are very big issues in non-will heirship proceedings. Happen all the time.
You mentioned the 10-to-1 rule, Riley. Outside of the 10-to-1 rule, why is planning ahead, even with a simple will, so important?
Well, I take the position in life that people like to have control. Some have accused me of being a control freak, but that's fine, because that's what I want to be able to lend to my clients in terms of making decisions where they make the decisions and they're in control. And estate planning and the execution of a will is at the very basis of planning for things not only that occur during your lifetime, but also after you have left the planet. And I think it's just vitally important for people to have that option, to consciously exercise that option, and to have the best advice of matters that they can control during their lifetime.
And I want to ask you one other question, Riley, because you alluded to it in a previous episode, but just in case somebody didn't see it. And that is this. These days, so many people have 401ks, they have IRAs, they have these contracts that specify beneficiaries, even if they don't have a will. So can you just tell the audience again how those contracts are considered separate from whether or not you have a will, and those beneficiaries will still be entitled to whatever is stated in those particular policies?
The Texas law provides that if you have a third-party contract that talks about the ownership and transfer of an asset, classically, as we previously indicated, is a life insurance policy, that contract will be honored and followed. And so what becomes very important is for those particular beneficiary designations for IRAs, for 401ks, for life insurance policies, for any company benefits, to dovetail with the will planning. And by that, I mean, let me give you a quick example. I have seen situations where the beneficiary designations are default beneficiary designations. That is, okay, you haven't specifically said how it should go, so we're going to go parent, or we're going to go surviving spouse, then we're going to go to children. Okay. And that's happened a bunch during my career, where there is no surviving spouse. There are children, and those children are under the age of 18. They can't hold money. And so what happens then is that very expensive guardianship actions have to be taken out for the money to be held for them until they're 18. So all of that could have easily been handled in trust provisions and provisions in the will dealing with what happens if a person under 18 is to receive assets of a person who passes away. And in fact, my typical planning is if someone would have given me money at age 18 and one day, that money would have been gone. So I can do in will planning and estate planning, you can create trusts for those individuals and move those ages out to age 25, to age 30, et cetera, so that those monies are held for their education, benefit, and support under the terms of the will. And then dovetail that with those beneficiary designations. So you not only sign the will and those documents as part of the estate planning process, but if the lawyer's doing his job, you dovetail that to make sure everything's covered from a planning standpoint on those beneficiary designations.
And just quickly, Riley, to reinforce for the audience, just because people might have those beneficiary designations in their life insurance or other 401k, that doesn't at all indicate or mean that they shouldn't also have a will.
Typical person has a great deal of their wealth in their home and in their personal property. Those are classically probate assets handled under your will. And the rest of their wealth now in non-probate assets, life insurance, IRAs, 401ks, et cetera. But I have met very few people that don't have both kinds of assets. And so you need to make sure that everything's coordinated so that the folks that are supposed to get it in the appropriate percentage that the person who passed away intended during his or her lifetime.
Great advice, Riley, as always. And that'll do it for today's episode of Texas Probate Made Simple with G. Riley Hetherington. Look, you heard it from Riley. Avoid confusion, delay, and family conflict. A simple will can go a very, very long way. Visit hetheringtonlaw.com to learn more or schedule your consultation. They are standing by to hear from you. And of course, don't forget to like, subscribe, and leave a review if this episode helped clarify things for you in any way. Thank you so much for your time.
Thanks for watching. Be sure to hit that like, and subscribe button and leave us a review in the comments.